The Drake Group Education Fund is dedicated to educating the public and professionals in our business with fact-based information featuring the experts in our profession so that we might all do a better job of helping college athletes realize the promise of an educational degree and becoming all they can be as students and athletes. So we welcome you to our 54th webinar. Thank you to all of our panelists for their time, expertise, and ideas. We have a fantastic panel today. And to all of you attending. Webinars provide us with the opportunity to share new ideas, recalibrate our thinking on issues, and get up to date on important topics. We are so pleased to have you join us. Lastly, before you meet our moderator and panelists, I just want to emphasize that our speakers are expressing their own opinions and not the opinions of the organizations in which they are employed or are members, unless they make that distinction in their remarks. Now I'm honored to introduce the moderator of today's program. Please meet Matt Brown, a college athletics journalist and newsletter writer for Extra Points, required reading, if you want to sign up for that, is his daily newsletter in college athletics, who covers business, policy, NIL, athlete labor issues, and NCAA governance. It's all yours, Matt.
Thanks so much, Julie. It is a pleasure to be here with all of you and a pleasure to be with this panel. To reiterate up front, unlike the other individuals that we will be hearing from today, I am not a practicing attorney. I am a reporter. I simply ask the attorneys questions and look forward to also seeing those questions from you, which I'll be happy to pass along. When you registered for this webinar, you should have received most of the biographies for the individuals here that we'll be speaking with, but let me just briefly introduce all of them to you and thank them publicly for contributing their time and their knowledge before we get into some of the questions. Today, we are joined by Andrew Brandt, a sports legal and business expert, a professor, media analyst with over 25 years of experience in the NFL, academia, and sports policy, including specific leadership roles with the Green Bay Packers, athlete representation, and NIL consulting. We are also joined today by Christine Brown, who I do not believe is a relation. We just have the same last name. She is a sports attorney with 30 years plus experience representing athletes, coaches, and teams in high stakes matters, including Title IX cases, NIL deals, eligibility disputes, and discrimination claims, with a strong record in administrative hearings and advocacy in higher education athletics. We are also joined today by Luke Fedlam, a sports and entertainment attorney who advises businesses and athletes on corporate strategy, contracts, NIL opportunities, and brand protection, while also serving as a leader and advocate in sports law and athlete development. And finally, we are joined today by Sarah Hartley, a trial and appellate attorney specializing in antitrust, athletics, and higher education law, focusing specifically on Title IX and workplace investigations, while also teaching sports law and contributing as a thought leader in our field here. So we're very fortunate to have such deep and varied expertise. I was wondering if maybe we can start with Andrew, because your background specifically, I think, is notable here. You've had a lot of experience looking at athlete compensation agreements, not just for college athletes and college athletes in the post-House era, but all sorts of professional athlete contracts. I'm wondering if maybe you could tell us a little bit, for maybe the legal layman here in the audience, what are the difference between those sorts of deals? Because assuredly what somebody, an athlete at Villanova or Louisville or any other institution is getting is not going to look the same as an agreement in the NFL, right?
Yeah, thanks, Matt, and really enjoy being here. I appreciate everyone inviting me, and what a great group we have here. You know, my background, as mentioned, is pro sports, basically an agent for many years, and then a team executive for many years, 10 years with the Green Bay Packers, did some consulting with the Philadelphia Eagles as well. And I'm used to a system that's not like college sports. I never thought I'd work in college sports because I never thought college sports would be pro sports, which it has become. I'll just say this, you know, in the NFL and the NBA and Major League Baseball, we're dealing with contracts that are multi-year. We're dealing with salary caps. We're dealing with drafts. We're dealing with free agency restrictions. I would call it law and order sports. As what's happened the last few years in college sports, especially the last couple of years, we don't have law and order. We don't have compliance staff that's involved in this. You know, when I did a contract with the NFL, I'd have two or three people on my staff working on contracts and cap compliance, and then we'd submit to the NFL, which had 25 people in cap compliance. It was very regulated. It was a secure website. We knew what everyone was paying everyone around the league, etc. Obviously, that's not the case. The one aspect that everyone's going to talk about, obviously, that's so different about college athletics right now is the unregulated portal and the perpetual free agency. So, in my consulting roles with schools, when I say to coaches, I'm just sorry you have to deal with free agency every year, they say to me, Andrew, we have to deal with free agency every day. And this is something that is so foreign to anyone that's worked in pro sports because the nature of pro sports is you're restrained from entering the market through contracts, through rules, through exclusive rights free agent, salary arbitration free agent, restricted free agent until you reach that golden ticket after 4 years in most sports, after 6 years in Major League Baseball, where you're an actual free agent. Of course, college is not like that, and we're dealing with that every year. We can talk as we go through this about what could change that and how we can fix that and regulate that. But it has been an eye-opening experience working in college sports these past 2 years because I was used to a completely different world in pro sports that was massively more regulated.
Thank you. I appreciate that. I'd love to hear from Christine next. And this is a question that's not about any specific active or completed litigation, but as a thing that I see as a reporter with some of the various lawsuits that are filed and what I hear from my sources from administrators is you're right, a concern that even if we had a contract, that we might continue to have free agency, or there's concern about the enforceability of some of the potential agreements that might be set up from school or brand or athlete. I'm wondering if maybe you could tell us a little bit about some of the specific legal questions that come up, even if a contract has been signed, that might not necessarily stave off free agency or stave off future litigation or stave off us having to talk about those cases in conferences like this. Why is this not as open and shut as it might appear to a layman?
Thank you, Matt. Let me echo Andrew's comments and thank both you and Julie and the Drake Group Education Fund for having me today. It's really an honor to be here and amongst such wonderful people. I get calls every single day about these challenges, multiple calls about whether or not an individual's agreement is going to protect them going forward. And the hard part is that I think we as a legal community have to decide, are we going to do the hard work now, or are we going to do the hard work later? And what I mean by that is we've got pieces of information available to us right now of where things are going. We have the NFL that has shown us how something can work. But we're in this era where we are evolving to a, a, a business that now has this influx of tremendous amount of money that we have to change the rules. We have to apply them in a way that keeps the athlete at the forefront. And I think that's, from my perspective, that's where I like to come in and like to keep my focus. And it's all about what is going to be best for the athlete. When we're talking about college sports, an athlete in college sports is there for multiple reasons. The primary being to educate, to get educated and to develop as a human being, in addition to being able to access the highest level of their sport that they've worked their whole lives to be able to develop in. And all of a sudden now we're talking about how that can be reflected in a contract that you wouldn't necessarily see until you were at the professional level. And so what's happening is we have all of these influences of people with opinions as to how this should be done on a professional level, and the athlete's getting lost in what is best for the athlete at that point. The perfect example that I can give of this has to do with eligibility waivers. I'm happy to jump into that. I don't want to get off topic from the question that you asked, Matt, but I think that the way to avoid having the litigation later, and what I refer to as doing the work later, and multiple litigation is for us to really be realistic at this point about the issues that are facing athletes and how do we evolve from the college athlete with no money to a college athlete who all of a sudden has access to so much.
Let me follow up on that real quick before bringing in the insights here from our other panelists. I'm wondering if maybe you could tell me a little bit more about doing the work now, just from your perspective or position as outside counsel or counsel specifically here for an athlete. Because I imagine, we haven't mentioned this yet, but it's kind of the elephant in the room, that boy, there was some sort of collective bargaining agreement, you wouldn't be able to have some of these concerns because it would be dictated elsewhere. But I don't believe any of the panelists here have the ability to unilaterally create a CBA, or unilaterally organize some other organizing body, or unilaterally change federal labor law. Can you tell me a little bit about what kind of work somebody in your position might be able to do, either at the front end or at the back end, to help better protect the athlete involved in these kind of conversations?
I think the number one topic that I can speak to is whether or not the application of Title IX is being considered in the distribution of funds. And I think that when I say do the work now, we have some evidence in front of us. We have, thanks to you, Matt, for with the FOIA requests and the work that you've been doing in getting that information available to us, that is enabling us to have the opportunity to do the work now. How much money is actually being distributed to female athletes? How much money is actually being distributed to Olympic sports, to the non-revenue generating sports? And if we give Title IX the respect and the authority that it deserves and needs to have, then we should be addressing these issues now, not waiting until next year when we have the numbers available to us to decide whether or not we're going to file a lawsuit and work backwards because women didn't receive their equal share or isn't in compliance with Title IX. And so if we look at Penn State and what they gave us in terms of information last week, we can see that just 0.66% of their budget was given to female sports. That is a perfect example of us having information available to us right now. And how can we work to educate institutions as to how they can make sure that they are addressing this issue, and that would be doing audits of their own institutions and determining what work they need to do in order to protect the athletes.
Thank you very much for that. And I hope you don't mind. I was taking notes on the side just because it is so rare that I hear an attorney say, "Boy, thank you, Matt, for sending all those FOILs." Normally, the response that I get is something that is less professional to say in front of polite company.
Yeah.
Sarah, if it's okay here, because this is part of your area of expertise, I would love your perspective on this level of kind of preemptive compliance or preemptive self-auditing here that Christine was talking about. Not speaking to any specific litigation, but if you're advising an athletic department or anybody else about risk management, what do you think should be done to as far as creating athlete contracts and handling this level of distribution to lower the chances of being sued in the future?
Sure. So thanks for having me. It's really a pleasure to be here. And I love that Christine has already flagged what I think is one of the key issues related to this whole new world that we're living in, which is Title IX compliance. The framework set up by the House settlement was a damages allocation that a lot of schools and conferences have looked to as they're thinking about how to allocate money under the revenue sharing system. I have written a lot of things on it. I'm happy to share with anybody who wants it, but I don't think that Title IX has any exemptions for revenue sharing or NIL license agreement distributions or marketing support for student athletes. I think it all falls firmly within the benefits for which an athletic department and a university have an obligation to make equitable distributions. So with that as the forefront, I very early on, as the House settlement was being contemplated and not yet finally approved, I was advising think proactively about how you can be supporting your female athletes, how you can be making distributions. And not everybody wanted to hear that. It's not necessarily a popular opinion that the law requires you to do this because there are some real economic realities, right? I don't like to talk about revenue generating and non-revenue generating because there is revenue generated by nearly every sport, not all, but there is some amount. But the reality is that the vast majority of revenues are coming from a very small number of sports because of the broadcast deals. Now, there are historical reasons, right, why the broadcast revenue is greater for the men's sports than the women's sports. So I think fundamentally there are some issues with using that as your framework. But the reality on the ground is that most institutions are getting the vast majority of their revenue from basketball, football, and not from very much else. And so the allocation has gone to those athletes, and there are very solid arguments that revenue sharing for the athletes who are in the sports that are generating the revenue should be getting it. Those economic realities don't impact your Title IX obligations, in my opinion, but I think that thinking proactively on the front end about how to handle that is something that schools could have and should have done. As to athlete protective measures that you can be thinking about beyond the Title IX issues, a lot of this comes down to how institutions were structuring their template agreements to work with their student athletes on NIL deals. There are schools that put in provisions that arguably are punitive. The student decides to enter the transfer portal. There are provisions that I think would be invalidated under liquidated damages law in most, if not all, jurisdictions. And then there are things that are, I think, entirely enforceable and reasonable damages models based on an athlete deciding to depart early. But there are things that you can bake into the contract where it's not trying to prevent them from transferring. I have personal views about whether there's some benefit to having continuity in a student athlete staying at a university, not just because of the athletic program interest in having them there, but just for the student athlete's educational opportunity. But I think when you look at the contracts, figuring out ways to make it athlete friendly while protecting the institution's interests as well is something that I was advising universities on the front end to be thinking about.
Thank you very much for that. I think in a second I might have a follow-up on the Title IX component, but there was one other thing here that you kind of alluded on that I'd love to hear maybe Luke tell us a little bit about, which was, Sarah, when I heard you to mention talking about some of these contract templates. And in my reporting and my understanding of this issue is that we have a few leagues that might have worked with outside counsel or somebody else and produced a template and said any of our members could use this as a baseline. And I am still a dumb layman when it comes to law, but my understanding is that the provisions of contract law might vary significantly from state to state, or what level of liquidated damages may be appropriate may not be the same from Ohio to Indiana or anywhere else. Luke, I'm wondering if this is something that you're comfortable talking about. Do you think, based on what you've seen and who you've talked to, can you give some other examples of things that an administrator might need to think about as they're crafting some of these agreements about how everything may be different from Ohio to New York to California, and for anything that might intersect here with college athlete compensation?
Yeah, absolutely. First, Matt, good to see you. And just want to say, thanks to the Drake Group Education Fund, Julie, and everybody there just for having us. I love these conversations. I've been listening to all the other panelists speak, and I'm just like, ooh, that's a good point. Oh, I can't wait to add some more to that. So thank you, because I think what Christine and Sarah just talked about in particular, I think is really important. And Sarah kind of talked about some of those examples when she talked about kind of punitive damages and liquidated damages and the punitive effect of some of these contracts. And I've been fortunate enough to work with athletes that are at a lot of different institutions and have reviewed these contracts. And it's interesting because even in your question, Matt, you talked about how there are conferences that have said, hey, use this as your baseline. And there are some institutions that say, oh, conference said we have to use this verbatim. We can't change anything. This is what it is, and use that as either their lack of understanding or their desire to really just have a uniform contract that all of their student athletes sign. And that is certainly not in the best interest of athletes. And, to Sarah's point, there has to be a balance around both protecting the institution, understandably, but also thinking about, we started this conversation talking about how student athletes are at the center of this college sports ecosystem. We've got to do something that also provides them a level of protection. So some things that I've seen that certainly wouldn't pass muster is that there are some conferences that include language that that basically has a student athlete covenant not to sue if it comes out later, which I'm sure we'll talk about, that they were misclassified as as not being an employee, and they actually end up being classified as employee, or covenanting, having a covenant to not sue over certain things in the future that absolutely does not pass under state laws in various states. But yet you end up having conferences that say, hey, here's this kind of template, if you will, to use. But again, I understand that schools, want their student athletes. It's a lot to ask a school to then say, hey, we're going to negotiate every single individual one of these contracts with each of our student athletes. That makes it certainly challenging. I think, from an overall kind of athlete-centered perspective on some of these contracts, the challenge is this: if we're looking at this new world, if you will, of college athletics, and we actually do believe that student athletes should be at the center of, or are at the center of what we're kind of have built this business around, we absolutely have to make sure that the athletes are getting the education and understanding of what it is that they're signing. And that's where I feel like oftentimes we fall short. Athletes, for the most part, have this unique opportunity to make significant amounts of money. And when I say significant, I'm not talking about just the $1 million deals that we're seeing regularly now. I'm talking about that student athlete that maybe had nothing that gets a $50,000 deal, right? Or a $25,000 deal, something that can be life-changing to them. They want to sign right away. And they don't understand what it is that they're signing, what they might be giving up. And while it's not the school's obligation to make sure that student athlete knows exactly what they're signing, it's certainly part of their responsibility to make sure that an athlete and their family understands what it is that they're agreeing to and getting involved in. I think there are a lot of student athletes that want to sign quickly. And if we look at the ecosystem as a whole, we know that the NCAA has its team of lawyers. We know the conferences do. We know the institutions do. But it's often the athletes, the actual ones that are participating in this space. And and Andrew can talk about it from his experience at the pros, where it's changed a little bit over the years, but for the most part, every pro athlete has their agent, right? That has institutional knowledge of understanding what is common, what is normal, and what is market, if you will, in these agreements. But now you have student athletes from all across the country that are getting whether it's institutional NIL, revenue share agreements, or even just collective NIL agreements or third party NIL deals put in front of them, and they just don't know where to start. And so the lure of just getting the money makes it easy to sign and say, I'll take it.
So
Matt, if I could
oh,
jump
please.
in, because
Please do.
again,
Yeah.
I think I'm the minority here on the school side of this. After spending a lot of my life on the player side, uh, a couple things. One is July 1, 2025 meant that NIL now stands for now it's legal, right? So everything done before that was on these collective contracts, and now it's legal. Now it's direct contracts between the university and the student athlete, which if you think back 3 years, like, oh my God, like you couldn't buy a student athlete a pizza 5 years ago. And now I'm writing multi-million-dollar contracts between the school and the student athlete. And just like when I started at the Packers many years ago, and I'm like, I just like, oh my God, I'm paying out tens of millions of dollars. Then you became numb to it. And at the beginning of writing contracts for millions of dollars for college student athletes, I'm like, oh my God, but then I got numb to it. Now it's just the business. And I think in trying to write these contracts, moving from the collective contracts, which were done by maybe not the university, maybe outside counsel, maybe someone in the collective, maybe a one pager, whatever it may be, to these formalized contracts, yes, there's going to be some different looks to these documents. And all the players I've dealt with obviously have been represented. Some have been mothers, uncles, friends, AAU coaches. But with the money getting so big, now you have a lot of experienced agents who also pass the contract along to attorneys that are not agents. And this has become a very sophisticated business in a very short amount of time. I think without getting into any specifics on the contracts, because I don't want to do that, but I do think what we look for from the school side is just don't, for lack of a better term, screw us. Like if you're going to transfer the payment stop, if you're going to leave the payment stop, if you get in trouble, just like Merle's clauses with NFL contracts, NBA contracts, the payments are going to stop. If, we can get it, there are more nuanced discussions about voluntary red shirts. And I've seen, student athletes, they see what they got. Listen, I'm not playing that much. I'm going to redshirt. I'll get another big deal next year. All the ways that people on the agent side look at it and say, hey, maybe we can game the system a little bit here. So the protections I always look for, having been on both sides of the aisle for many years, are like, just don't screw us. And from the school side, we don't want to screw them. We don't want to terminate the contract. We don't want to do these things, but it's like just protections. That's all we're looking for.
Matt,
I
if I can,
oh
I can't
yeah,
help myself. If I can just make one comment,
sure.
the issue is we're dealing with a community where most of the athletes are 18 to 22 years old, and they're coming to an institution that they've revered for years and years of their lives, that they have wanted to go to and wanted to be a part of, and thought was their avenue to being successful in their sport going forward. And they presume that the institution has their best interests in mind. And so there you're when you I think, Andrew, when you say, just don't screw us, I don't think that the 18 to 22-year-olds necessarily know that something that they're trying to do for themselves and benefit, or trying to figure out this landscape of what is in my best interest. They don't have that education yet, and they're looking to the institution for the education. And we've got this dynamic where they're automatically at odds with each other because they're entering into this contract involving huge amounts of money. So, how do we deal with the fact that we're dealing with a community of people that still need education and advocacy, because they don't know whether they're doing the right thing or the wrong thing, and they are acting on the presumption that this amazing institution that they've now become a part of is acting in their best interests.
I'm so glad you mentioned that, because that was actually exactly what I was going to ask this whole group about. And I wrote it down as Luke was talking, that you want the money when you're 18 or 22, and someone slides a paper across your desk, and if you have a problem with nutrition, with your ankle, with your academics, or so many other things, if you're an athlete, the typical impulse is to go to your coach. Go to your dobo, go to somebody else in the building. And I don't mind sharing this. I have learned this in my career, that your boss or the other person that you're entering into a contractual relationship with might be your friend now, but they might not be your friend after you tear your ACL or after something else happens here. You kind of alluded to this, and I heard this, I think, a little bit from Andrew and Luke, and I'd be open to hearing from any of you four. I would love to hear what your advice or potential solution would be to that dynamic of an athlete needs help deciphering an agreement, and the athlete can't go to the school because that's management, and the school might feel some sort of moral or institutional obligation to do so, but can't effectively advise the person they're negotiating against. How do people find that information besides obviously hiring the four of you? What advice can we give to solve this information gap?
I'll chime in here because, like Andrew, I'm usually, well, always on the institutional side. And I've negotiated a lot of these contracts, and there's always, in almost every circumstance, an agent or a parent or an attorney who's on the other side. And I wish that this was all naive student athletes who were coming to the table really not thinking about what the potential ramifications are, but these are business transactions. And it is about getting as much money as they can and maintaining flexibility to be able to transfer if they choose to do it. I mean, that is the part of every single conversation, whether it's with the student athlete directly or with their team. And so I think, yes, 100%, every student athlete who feels like they need some type of advice should get it. And whenever I send an agreement on behalf of an institution, I advise in the email that I send it off with, please consult with whoever it is you need to, do that, because recognize that they are young people, but they are on message boards and there are parent groups and there are people out there who are putting a lot of information in people's ears, and they are self-advocating very aggressively, and sometimes not in ways that I would think are in their best interest, thinking of it as a 1 year or even shorter term for many of these student athletes. And that, from the institutional side, I see that as counter to their long-term educational interests. But I'm curious to hear what those who represent the athletes think of that, because I have always advocated for more athlete-friendly agreements, but I'm often having the student athletes coming in and asking for things that are absolutely crazy in my mind in an educational environment.
I'll just jump in because I think people are asking for a lot of crazy things now because it is the wild, wild west, right? As overused as that phrase is, people, I had a call with a family yesterday, and I know we'll talk eligibility, I'm sure, at some point. It was a sophomore athlete that plays basketball, played 20 plus games already, but had some injuries along the way that wants to get that year back. And it's like, wait, but what are you talking about? But it's like, well, I've seen all these lawsuits, so I just want to make sure I have as many years as possible. So people, I think there is, and you use the word kind of, Sarah, like naive, right? And you would hope that it's a naivete. And I think sometimes, these are sophisticated transactions, but there are also, there's sophisticated transactions with professionals and family members on the other side, but that have no experience in looking at revenue share agreements or dealing with, institutional NIL deals and things. Yes, I've talked to many families that say, "Oh yeah, my neighbor's a lawyer," and yeah, okay, well they're an estate lawyer or a tax lawyer. Like that doesn't mean they understand what's normal in market in this space. To your question, Matt, what I would maybe offer is we're at this place where it's being written what college sports is going to look like now and into the future. Very much we're in a place where some people, some organizations, some institutions are being proactive, and others are maybe waiting for someone else to make a decision as to what it looks like. But if we were to create this and think about it, and what makes it so challenging, I think, is that sometimes we have to understand that there are other things that may happen that cause us to change a bit. But as of right now, student athletes are not employees. There is no collective bargaining. There aren't collectively bargained for agreements in place. So everything is unique to what that institution or that conference wants. If that's the case, then what is being done to say, how do we make sure that we level up the knowledge and education and understanding of those who are around our student athletes, not just the chat boards or the parent group texts of like, well, I got this, so you should go after that. But more so, what are the actual traditional terms of these types of agreements? What does it mean? I've talked to families that don't even know what liquidated damages means. Sure. Right. And we've talked about it like it's nothing here, right? So there are a lot of just basic core fundamentals, I think, that would be helpful if there were a way for us to say, there is, if we care deeply about the student athlete and the student athlete being the center of this college sports kind of ecosystem, then we're going to put things in place, we being the institution, the conference, or the NCAA, to say we're going to educate those that encounter or interact with us in a way that at least we're not telling them how to negotiate, but at least helping them understand the fundamentals of what's included in these types of agreements.
I think we have
Well,
to I think we have to inject some reality here that may not be as fairy tale as some of the people think. Like, in terms of people like wishing their whole life to go to this university. Sometimes, and a lot of times, I'm dealing with student athletes that just thought about this university on the first day of the transfer portal when they contacted them. They never thought about that university. They never pick a name. They never thought about Tennessee until some guy from Tennessee said, I'll offer you this kind of money. So this is not a situation where we're dealing with, oh, someone who just grew up their whole life wanting to go here. Yeah, maybe there are some high school students like that, but I personally don't really negotiate high school contracts. We're dealing with transfer portal. I did dozens and dozens of football contracts in January that I don't know if those people wanted to go to the school they're going to any more than a month, maybe. Um, this is pro sports. I led with that, and I think we have to understand that. There's not a lot of naivete out there. As someone who's in the trenches, and as I said, if they're not lawyers, they're sophisticated agents. If they're unsophisticated agents, there's usually a lawyer redlining the contract behind him or her. Um, I think we have to understand what college basketball and football have become in these transfer portals. And we can talk about high school in another context, but this is serious stuff where if you don't pay what your competition is paying, you're out. And these decisions are made in a matter of minutes sometimes. And then you sort of come up with the cleanup crew to do the contract. But this is high stakes stuff.
I guess I
Matt,
would
if I could
just
jump
say
in.
I want to hope, are we talking about the 1% or are we talking about all athletes? I think that's one area where we really need to be clear because I think for what you say, Andrew, for the 1%, that's true. But there's a significant argument out there that we're not talking about all the other 99% or whatever that is that they're not the $1 million deals. They're the lower deals, and they are coming from families who have no experience with signing contracts. And those are the ones that the institutions can't just say, sorry, we're not going to educate ourselves and we're not going to provide you, we're not going to expect it of ourselves. And so, and we're just going to presume that you're coming after us for whatever's going to be best for you. I understand what you're saying at that high level, but we're talking about college sports with lots and lots and lots of athletes that are being offered all varied different amounts of money. So.
And I was going to say something very similar to Christine because it oftentimes it is the football tail wagging the rest of the college sports dog, right? And we talk about these very, there's certainly the 1%, the high, the $1 million, multi-million-dollar deals, but then it's those agreements that the school says, okay, this is our rev share agreement, and so now a women's volleyball player is signing the same agreement as a football player, right? And it has the same impact, et cetera. And that women's volleyball player may not have this level of sophistication around them to understand what it is that they're agreeing to, nor have a desire to want to know, like, well, if I transfer right away and those kind of things. So that's where I feel like, and again, this is a much longer conversation probably for another webinar, just around the kind of some of those differences that football brings to the table in particular because of the dollar amounts, because how big it is versus all of the rest of college sports, maybe minus, basketball, men's basketball.
On that note, I would like to quickly shift to a question that is probably less relevant to football, although still relevant to high-level college athletes across the board. When I began to report on this a few years ago, the guidance and understanding that I got from immigration attorneys and from many schools before House was, if you are not a U.S. citizen, if you are an international athlete who is here on a student visa, by God, there's a lot of restrictions on what kind of NIL money or opportunities you'd be able to have. And unlike the NCAA, which might send a threatening email, but then maybe not do anything for 6 years, the Department of Homeland Security or various federal departments can enforce penalties much scarier than a show cause. And I would talk to athletes who were like, no, I couldn't do this $400 deal with Runza in Nebraska because I'm Swedish or something. But now, if I look at college basketball in particular, but also volleyball and some other sports, we have large numbers of international athletes, some competing at a high level in Europe and South America. And I presume that they're not coming to play basketball or volleyball or hockey for no money. And I'm wondering, I guess I'll start here with Sarah and Christina, then kind of open this up. I'm wondering if you can help me understand what is the mechanism that a school can use to directly compensate an athlete who might be here on a student visa without recklessly endangering their green card or their visa status?
I can take a first run at it. I think the background, of course, right, is that with an F1 visa, a student athlete can't do work in the United States with some very limited exceptions for on-campus work. And so historically, we've had to be very, very careful about any deals that would have a student athlete doing work, period, like end of story. And so I was not involved in any collective deals. That's not sort of my area, and maybe someone else can speak to how those folks are handling it. But I think theoretically, the ways that you can handle the reality of the F1 visa situation and the risks with the current political situation in the United States as a foreign student athlete is to make sure any agreement you enter into has zero work requirements in the US, and that the schools are actually abiding by that, by not having the student athlete do anything. And so your agreements can be royalty only. There are ways you can get around any type of work requirement and still do an NIL license agreement, right? It can be, we're only going to use photographs that are taken in the ordinary course of you playing your sport, as we always have had the right to do. There are other things that can be done, such as having foreign entities where they're solely owned by the student athlete, and you can have a licensing agreement with them. And there are ways that you can handle it, but it is still a very uncertain area, no matter how you cut it.
Thanks. Have you heard anything different?
Well, I agree with Sarah, and I've seen the term royalty in some of these agreements, but I still think that isn't solving the problem. I think that's still running a very risky, traveling on a very risky road. And I would compare it to Title IX. It's basically saying, we're almost ignoring the fact that we're supposed to be distributing this money equally, or we're ignoring the fact that we're not supposed to be doing this. And can we call it something different than what it really is? And I think that the reason that it's happening now, Matt, is just because there hasn't been that legal challenge to it yet. And people are quote unquote getting away with it at this point. When I say people, if maybe they are calling it something different. And I think we're facing again, do we do the work now and try to get it to a place that is the right way to avoid the litigation, or do we wait for the litigation to solve it?
Thank you both. As a quick housekeeping note here, participants, the folks that are watching from afar do have the ability to submit a question via Q&A. And there's one I'd quickly like to address now before we can get into some of the other ones. And I had a few other things. To go back a couple of questions, I want to paraphrase here from listener Morgan Powell, who would like to hear more, not just from Sarah and Christine, but maybe we can start there, about the other risk areas that schools need to consider for Title IX compliance beyond just how they're distributing house-related payments. Specifically pointing out that I think it's the Schroeder v. Oregon lawsuit, which also, if I remember correctly, you had components about publicity and components about facilities and access and things independent of house-specific revenue sharing, because this came out before House was codified. Beyond potentially distributing direct, payments in a Title IX proportionality compliant way, what are the other things that you would recommend schools that need to be specifically concerned about in this new era as far as Title IX is concerned?
Uh, Thanks, Morgan, for the question. Um, Everything that you've had to consider under Title IX for the last 50, almost 3 years, still the same. Nothing has changed there. The law is what it has always been. You have to consider all of the various benefits and treatment factors that you have always had to consider, and you should still be providing equitable opportunities in terms of participation. No question on that. The area that I think is adjacent to the revenue sharing and NIL license agreement is what you were talking about there with the sort of marketing and marketing support. And that all, again, it's not in question the way revenue sharing has been sort of put in question as a political issue. It is really the same as it's always been. If you're going to promote women's sports or men's sports on your website, you should do it in an equitable way. If you're going to provide NIL deal support in terms of finding third-party deals for your male athletes, you need to do it in an equitable way for your female athletes. So I honestly, I just don't think there's anything different. And you can be auditing yourself, and you can be hiring someone to do audits for you if you feel like you have questions about whether you're doing it in the right way. But I think that it's something to pay particular attention to if you are doing anything to support your student athletes finding deals beyond the ones directly from campus.
Thank you. Christine, did you have anything that you wanted to add there, or?
I think Sarah's answer was absolutely on target, and I support everything that she says. And that for me, the bottom line question comes, and this was part of a brief, an amicus brief that we wrote as part of the House settlement. It all comes down to investment. Are we willing to invest in female athletes as much as we have invested and continue to invest in male athletes? And the latter distribution and all of that comes from a direct pattern of a lack of investment in female athletes. And so the fact that female athletes haven't had the deals, that male sports have had, it doesn't allow for the numbers to be there to legitimize that they should get equal distribution. So to me, we go back to square one, and institutions looking at, are we going to invest in much and believe that female sports can generate that revenue if with the right investment?
Thank you. I have another question here from the chat that I think might be best directed to Andrew first, and then potentially also from Luke. This is from listener Bethany Beal, who asks, given the tension between what schools are paying for on paper and what the schools are actually paying for in reality when they're dealing with athletes, what have you advised clients, whether they be athletes or schools, on how advisable it would be to enter into a multi-year revenue sharing deal? I'd love to better understand the risk reward calculus for both sides on trying to commit to something over a 2 or 3 year period.
Well, let's talk theory and reality on multi-year deals. Like
Please,
I
I'd love to
said,
hear both.
coming from the pro side, multi-year deals are obviously the norm. What I've experienced in college the last couple of years, they're completely the exception. If you talk in theory, what's the advantage of a long-term deal, or long-term in this world is 2 years? From the school side, you get certainty and you get protection from the transfer portal next year, and that's obviously important. But then the question is, which has been sort of rattling around this conversation, is what's to bind the athlete? What is really to bind the athlete for a second year? And from the athlete side, what is really to bind the school for a second year? What if the player's not very good? The coaches don't want him to return. There are all those little sort of extra side effects to it. From the practical point of view, and again, as Christine mentioned, I'm talking about the top earners, the top leveraged student athletes in college football and college basketball. No one will do a 2-year deal. From the school side, great. We'll talk about it. From the student athlete side, and we again getting past the naivety, agents, managers, attorneys, parents, nobody wants a 2-year deal because 2-year deals eliminate optionality. And that's what every student athlete seems to want the most, which is if this doesn't work out, I'll go somewhere else and I'll keep my free agency open. And yes, we haven't even talked about student athletes now going to 2, 3, 4, 5, 6 schools. And where are they going to connect with an alumni, in 10 years, 15 years? That's a whole nother thing. But yeah, I'd love to do 2-year deals. I'd love to do 5-year deals. I'd love to do real deals rather than just this free agency every minute of college sports right now. So uh, it makes a lot of sense theoretically. It's not happening practically.
Has that been your experience too, Luke?
Yeah, I agree wholeheartedly. I think, I think about what we're talking about. We're talking about a really a revolutionarily new college sports environment that's happened over the last 5 years. I mean, really, if you think about it, we're talking about a whole new world of college sports so quickly. So early on, 20, not really 2021, but 2022, that's when collectives wanted to have multi-year deals with student athletes. Now to Andrew's point earlier, who knows who you had drafting those agreements, especially early on. But the market starts to evolve. And I agree that I think what athletes want the most is kind of that flexibility and the freedom to be able to quote unquote bet on themselves, go after other opportunities, etc. However they frame it. But there are also some significant challenges, and Andrew mentioned many of them. And one of the biggest ones is not just what alumni do you associate with, but did you actually earn a degree? What is your progress towards actually getting a degree in all of this? And I'm unapologetically pro in favor of athletes. I want to help protect them to have all the opportunities in the world. But there's also this thing called a degree that for most athletes that are not going to play professionally, that degree really does actually matter. And so I think that's something that has to be part of the calculus. But I think, yeah, if schools were offering multi-year deals, the challenge would be that the athletes want to have the freedom and flexibility to say, well, if this doesn't work out, and there are a lot of different reasons as to why it may not work out. And let's also not forget, coaches leave too, right? And so, coaches leave, they go to other opportunities, new opportunities. And so, student athletes need to be able to, make the best decision for themselves, because now these decisions that they're making truly are business decisions.
Yeah. Let me ask all four of you here about a different kind of business decision, which is a question that came in here that I legitimately have not contemplated, because so much of the conversation that we're talking about right now has mostly been kind of shaded by the experience of football and men's and women's basketball players. But we have lots of other sports where prize money can represent a meaningful amount of potential annual income, whether that's in golf or tennis or swimming or some of these other potential places where you might compete in a non-NCAA event and potentially earn something, or shoot for esports. If that continues to become a thing on the college side, that's very much the template. And I'd be curious from anybody that has some thoughts here. How might athlete compensation or athlete school, kind of contracts evolve or look different as they contemplate income that isn't from marketing and isn't from house, but potentially from winning some hypothetical invitational tournament over the summer?
So I don't know that it's necessarily a matter of contract on the front end, right? There's pending litigation about the rules around prize money based on the NCAA rules regarding that. So I think given the current lay of the land, we're operating in an environment where unless and until that changes, I don't think contract impacts what the student athlete would be permitted to do as a matter of NCAA policy. But look, I mean, as the parent of a tennis player, it does feel weird that, a tennis player cannot go and earn prize money over a certain threshold. Probably is not getting NIL at most institutions, whereas the football player is getting a boatload of money potentially. But that is just something that will have to play out. I don't think it's a question of how we structure contracts on the front end at the moment.
Thank you.
I'll,
Christine, did you have any thoughts on this too?
I'll just add another complicating factor to that.
Perfect.
A lot of the questions that we're receiving have to do with being able to play over internationally during the summer, and whether or not playing internationally, even if they're not receiving any income, whether or not that is affecting their eligibility or their and so it just goes to show that the influx of these issues regarding the revenue sharing is dismantling all of the NCAA rules as they have always existed in a way that they have all got to work in synergy, and so that is the cascading effect of that is affecting many different issues as to whether, and confusing athletes as to what they can and can't do. Everything seems possible because of one case that somebody wins and they get their eligibility back, or because they are able to argue a portion of their contract in a successful way. But until the actual Bible that we're all operating from evolves along with this, I don't think we can solve those issues in individual silos.
This is something that I've reiterated a couple of times in my own reporting too. And if we all had the answers of one individual person had that, this is how we're going to change that Bible. I don't know about you four. I would be in a very different line of work. I'd probably not taking this call from snowy Chicago. I'd probably be taking this call from the tropics. I want to shift away real quick to something that I think is also important to mention here, because a lot of what we've been talking about has been primarily concerning house settlement revenue sharing type agreements, where the school is one party, the athlete is another party, and in some of the cases where Andrew was describing, that it could be for millions of dollars, and if not millions, it's usually some amount with a comma in it for this type of work. And one of our listeners here, Max Rusakov, comments brings up a point that I've thought about too, as somebody who has done NIL deals with athletes before, and I have paid them to promote things. Max asks if the median NIL deal is being around $49 and median total earnings across all of college athletics, not just ACC basketball players, but if the median total earnings for everybody are around $700, how are athletes supposed to handle the real risks in these contracts that are being drawn up when hiring legal help might cost more than the deal itself? I'd be interested in hearing what all of you think about this too, because when I've done deals that I don't mind admitting have all been under $500, I have not had a lawyer draw it up because, that would have cost me $300, and then this whole arrangement wouldn't have been profitable for either party. What would you all recommend?
Yeah, I think there's a couple things to think about, because I think the numbers shared, right, are real when we look at the median and we look at where everything is at, but I think there's a difference between third-party NIL deals and institutional rev share, institutional NIL deals, right? So there's certainly a level of sophistication there that is, and leverage imbalance between institution and individual athlete that certainly requires professional advice through that process. The third-party independent, business that wants to do a deal with a student athlete, yeah, I mean, I think that's something that both parties have to decide. Is the deal worth it to have outside counsel to help draft it? But I think there are some institutions that are proactively trying to deal with certain things like that. There are some schools that happen to have law schools on their campuses that do, that they have their own kind of clinics that they'll use where student athletes for free can have law students, covered by professors, review those contracts and things like that. There are opportunities for those types of deals to get that kind of free/pro bono legal advice to understand. And I think there's also, again, understanding what are just the big red flags, right? Ultimately, if I'm doing a $500 deal, I just need to really know, what am I getting paid? What do I, what do I need to do? What services do I need to provide? But then ultimately, like, I just need to make sure that they're not going to have the rights to my name, image, likeness, forever, forever and ever, amen. So, I mean, the levels of complexity when you're talking about a multi-million-dollar deal that's an institutional rev share deal versus a $500 promote our brand, promote our company deal, much different. But the advice is see what resources exist already on campus to try to help navigate that for free.
Thank you. Is this
I
something
remember.
that your students do, Andrew?
Yeah, I do have them involved in that. And I did that, when it first started. I mean, when you bring this up, Matt, and then medians, and I can't comment on whether those numbers are correct or whatever they are, but
Same. I'm just
it just
I am reading the
it
prompter
just
here. I
brings
don't know.
up this like we look at it like now we look at it as like the 1950s, and this was 19 in 2021, 22. These were most of the deals. These were most of the NIL where you did a shout out on Instagram for get some free product, a meal plan, where you could do a coaching opportunity for 200 bucks an hour. Like, and then something called collectives got involved, and this became a completely different animal where we're doing, I guess, as we've talked about, multi-million-dollar contracts and unlimited transfer portal and unlimited free agency and millions of dollars. And we haven't even talked about the fact that, all these schools opted in. And when you opt in, you're making a commitment to pay a lot of money to student athletes. And then what I don't even know if they're thinking about we got to pay women the same thing with Title IX. It's like we're building the airplane on the tarmac. And yeah, of course you're going to try to get some help for $500 deals, but schools have gone way past this. Like we're in a whole nother era. That was 21, 22. That was an era where, yeah, you were doing these one-page deals where, make a couple shout outs on Instagram and get some product, get some merchandise. But as I keep saying, we're in pro sports. And the difference is that obviously we don't have collective bargaining. Obviously, we don't have some of the nuances of pro sports, but some of the things are better than pro athletes have. And that's primarily free agency. And there's nothing that creates more leverage and money than free agency in sports. It's And I'll just say this again. In the NFL, if we had a free agent, he's negotiating potentially with 29 teams. In college basketball or football, you have a free agent. There's 100 schools in the Power Five, at least to start with. Like their options are so much better than a pro athlete. And that's what I keep coming back to when we talk about this. This is another world. Trying to get
Can I just
Yeah.
add in one thing on that, Matt? Because
Sure.
it's not only is it a better world for the college student athlete in some of these respects. I have the opportunity to I talk to I don't know, work with a bunch of different NFL teams, talk to their rookies, second and third year players, and one of the things I say, we've done some conversations around from NIL to the NFL, and one of the things I tell them all the time: collectives don't exist. Fans aren't going to be giving you money to stay on this pro team anymore, right? Like if you think about it from a college perspective, there are literally people outside of the institutional money. There are donors, boosters, etc., others that want to give money to have an athlete play for this team. That absolutely does not exist in pro sports. Why do I bring that up? Because we owe it to student athletes to help set their expectation of what reality is while they're still in college. Because guess what? The student athlete that let's just say is making 125,000. We're not even talking about the big money. The 125,000 that even though it's like we start to become numb to these numbers, like Andrew said earlier, that student athlete making $125,000 doesn't go pro and then gets a job offer for $52,000 and they actually have to show up to work every day and do something. That is a mental shock to the system. And I think that's where we have to equip athletes, equip athletic administrators, coaches, etc., to help remove some of that numbness to say this is not normal. You have this unique period of time, right, where you have this opportunity, but this is not what the rest of life is going to be like. And we owe it to student athletes to help them understand that.
And I'm glad you brought that up. I mean, to be honest, this is a major reason why I don't do these kind of deals myself anymore. I am blessed that Extra Points as a company has continued to grow, in part because of the support of many people on this panel and who are listening. I do not have the kind of money to give people 300 grand because I want them to go play for American University basketball. I do not have Patriot League like bagman money. I'm paying people 400 or 500 bucks to do, write a post or do some Instagram work. And if somebody's thinking, but I make 125,000 for waking up and lifting weights. Why am I going to do anything for 500 bucks? You can't get the right person. And then, of course, they move forward. Not only do collectives not exist in the pros, I live in Chicago. They're trying to get us to help pay for to keep the Bears from moving to Indiana. We don't want to do that. We're not going to pay to keep a team from existing, let alone to go pay some right guard to go play. All true. Extremely different environment here in many ways.
Let me just say, in
Please.
response to Luke sort of teed up we haven't really talked about, just spend a minute on it. What I think there's 65 eligibility suits. I mean, it's like, I look at it and I'm like, yeah, why not? Like the percentage of these people that are going to play pro sports is minuscule, minuscule. So if you can make a couple $100,000 for 7 years playing college sports, absolutely. I totally get that. Before you have to enter the real world and make $50,000 and show up every day and not get a car and not get a nice apartment. Sure. So, eligibility suits are coming down all over the place, and we make fun of these guys going into their seventh, eighth, ninth year and fifth, sixth, seventh school. But again, now taking myself out of it, looking at it from a distance, I'm like, absolutely, if I was a college athlete, I'd try to play for 12 years. Why not? Why not?
Oh yeah, to your point, right? Like Andrew, I've been in some NFL, professional facilities, and I've been in Northwesterns. And what Northwestern's got, not that great of a football program, is nicer than many NFL places facilities that I've been to. I've been to many college basketball facilities that are nicer than what you'll have in the G League or the French benefits. Get that too, which I think then kind of ties to something I should have more explicitly asked, I think, earlier in this conversation. I think Andrew's right. The motivation and desire for an athlete and perhaps that athlete's representation to Van Wilder their college career and stay for 20 years if possible is very clear. Is there anything that you think an attorney working on behalf of a school or one individual school can do to better protect themselves again from eligibility lawsuits, or do you all see this as a problem that can only be addressed at a larger, more collective side of the equation?
Well, I mean, maybe I'll start off, and
Please.
please,
Yeah.
everyone else jump in, right? Because there is no definite solution. I'll start off by saying this. I don't know that it's an institution that needs to kind of protect itself in this way because it's the NCAA that sets the eligibility rules. And I think, when we look at the lawsuits around eligibility, it's, against the NCAA and their bylaws on whatever it may be, from transfers to counting years to medical hardship, et cetera. I think if we kind of were talking, kind of behind the screen or whatever before we started the webinar today, and this comment about lawyers being involved in doing things, but then also in not doing things and organizations not being involved. And I think one of the challenges that the NCAA faces as it has really been kind of hands off in a lot of this, right? Now, obviously, it was involved in the House settlement, and getting to that settlement. But when you look at the significant, massive change that we've seen across the college sports landscape, and that no bylaws have been updated, or addressed, or voted to be changed, that creates challenge and opportunity. And I think the idea that to say that we're going to continue to wait for Congress to step in and act on this creates what we have now, right? Creates continued lawsuits, continued chaos, continued wild, wild west, experiences, because there is no definitive, people talk about guardrails all the time. We lost guardrails years ago. And so now it's just a matter of, what can a school do to protect itself? The schools are the members of the NCAA, right? I mean, the NCAA often gets cast as this sole thing out doing its own thing. Well, it's made up of its members. And so ultimately, its membership has to decide: are we going to just continue to let the lawsuits kind of come as we wait to see if we get some level of protection, safe harbor, beyond antitrust exemption, whatever it may be from Congress, or are we going to try to modernize our bylaws to keep up with this rapidly changing space, knowing that there may be lawsuits that come from the change we make, but you can't let the fear of that stop you from trying to make progress and trying to move the industry forward. My 2 cents, not my firm's perspective, just my perspective.
Of course, all of us here, in case we need to belabor this point, all of our panelists are speaking on behalf of themselves as private citizens and not on behalf of any firms, the NCAA, or individual institutions.
Well said.
On that note, Christine,
if I can, Luke, thank you for those comments. I agree with you wholeheartedly. And I'm going to tell you specifically with respect to the eligibility issue, from my point of view, the way that institutions could protect themselves right now is to get out there and say, you know what, athletes should be able to submit their own waivers, that it shouldn't have to go through the institution. Right now, if an athlete wants to get a waiver to get more eligibility, it can only be submitted by the institution. Athlete can't even do it for themselves. So if institutions want to protect themselves, put it back in the hands of the athletes, because, and I have it on good authority that there is going to be a pending matter in the court system that addresses the fact that the athlete, without the ability to file their own waiver, is reliant upon the institution to advocate for them. And guess what? Mistakes get made. And when an institution makes a mistake regarding the athlete's situation and submits that to the NCAA, and the NCAA makes a decision based on what the institution has reported is the athlete's situation, and it was wrong, the athlete then loses their ability to participate. And it's a perfect example of why, to Luke's point, why the archaic, I shouldn't say archaic, but well, I'll say archaic, bylaws need to evolve.
Thank you both very much for this. This is I was not personally aware about the specific restrictions about who can file some of these waivers. I think that's an important thing here to talk about. We are running
quickly, Matt, you
ahead.
asked about school versus NCAA or some governing body. I think that's what has to be done on the eligibility side. I don't see any ways school by school can do that. But as we know, and as we're all here, and it's the theme of NCAA sports over the last 3 years, is that any bylaw the NCAA puts forward like this, there will be lawyers. So, we can all say the NCAA should do X, Y, Z, and they know as more than we know that anything they try to do that, here come the lawyers. So we're sort of stuck in this cycle right now.
That may actually be a good place to kind of segue to. I think we have time for maybe one or two more of these in here, but I want to paraphrase two kind of combined questions that I've gotten in the chat about the sort of what is like in the similar vein, what a school can do versus what the NCAA needs to do versus what other structures need to do to prevent the onslaught of lawyers for everything. And we've talked throughout this seminar here about protecting oneself as far as NIL compliance is concerned. And there's a prong of that that's related to how specific athlete compensation is divided up. We have prongs of that related to marketing and exposure obligations, about scholarship opportunities, about facilities, about meeting these other prongs of compliance. And I would be interested in really the four of you. For one, if you see mechanisms to compel non-compliant institutions to comply beyond adversarial litigation. And if there are mechanisms there, what are some things that could be done either by friendly and knowledgeable attorneys or other groups to help push for this, knowing that litigation, while effective and a critical component of our legal system, can also take forever. Are there things that could be done that do not involve signatures on legal letterhead and $800 an hour attorneys to maybe nip these problems in the bud a little bit earlier?
Okay, why not?
Sure.
I'll take a shot.
Please. I mean,
I have no
better you
idea.
talking than me.
I mean, I don't know, but
Sure.
one thing I think could be more interesting is more transparency, right? If there were more transparency on, let's just take Title IX and NIL for as an example. If there was more transparency on what each school is doing as it relates to not just the roster numbers and scholarship numbers and things like that, but actual like this is what we're doing to promote brands, give access to NIL, tools, mechanism for growth and visibility, et cetera. Like if there was more transparency, then I think there's more accountability, right? But right now in this NIL space, every school, I mean, there's, confidential, I won't share the institution or whatnot, but there have been schools, and one in particular that has terminated an athlete's NIL deal because of he breached confidentiality, right? And shared what he was getting, et cetera, et cetera. Schools, understandably so, are fiercely protective, just like brands and companies are, of the deals that they do with their student athletes, et cetera, in terms of dollar amounts, et cetera. But at the same time, in terms of what the institution is doing to promote certain things, to put things in place, to help, across the board, I think more transparency there would be helpful to help hold schools accountable. But right now, nobody knows what everybody's doing unless they're getting it from word of mouth. Well, they said that you're doing this, and I'm not getting this, and that. It just creates the wild, wild west because everybody's trying to go after any and everything that they can. But if there's more transparency, maybe that's one way to help in this space.
Luke, from your lips to God's ears to the ears of university general counsel and open records clerks. All right, I'm not. Am I saying this because I'm a little bit self-interested? Maybe, but yes, Matt Brown, huge fan of transparency. Many of the things that you were talking about there in terms of not just what kind of money is being distributed, but what you're sharing with your individual athletes. I have tried to get this and then run into FERPA or run into screw you, pay $16,000. I won't name the university, but we don't have to be Encyclopedia Brown to figure it out. If this information is not leaked to me, that's okay. If it's leaked somewhere, let me wholeheartedly endorse your thinking. I would love for more of this stuff to be publicized and transparent so we can compare receipts. Sarah, please.
So can I tag team on that? I think transparency obviously is a challenge, right? And it's probably why we haven't seen the first wave of Title IX litigation, because we just don't have a lot of data, but we do have a lot of public facing statements from athletic directors and institutions about what their plans are and what they were going to do. So there is a lot of information out there. I think that the missing link in all of this, as we're talking about athlete focus, is trying to get student athletes to advocate for themselves and for these issues. And that's always been a real challenge, right? To position a student athlete against their institution or against their coaches is a huge ask. But that missing link of the interested parties, the most interested parties, having a voice in this conversation, I think is part of why it doesn't get acted upon as quickly as it could by institutions. If the commercial interests were counterbalanced by every single female student athlete coming into the athletic department and complaining that they're not getting treated properly, maybe we'd see some differences. In the early days of Title IX, that's what student athletes did. For those of you who haven't seen it, there's the very famous picture of the Yale women rowers going to the athletic department with Title IX written in paint across their backs. I mean, there are things that women athletes, and it's not exclusive to women, to advocate for women, anybody could go and do to support their women in this in particular. And I think transparency would help, but really educating and empowering people to understand where that inequity lies and how it can be addressed, short of litigation, would be a wonderful first step.
Thank you, Sarah. A great point.
Just one more additional point to that. I think we've seen this before. We talk about Title IX. One of the areas we haven't discussed is that, 15 years ago, we were faced with very similar challenges when we were dealing with the epidemic of sexual assault on college campuses. And there were expectations that students would come forward, whether they were athletes or not, and have the ability to advocate for themselves in the area of sexual assault. But institutions were all of a sudden taxed with the burden of having to have a process and procedure by which a student could have that access to be able to advocate for themselves. And we've seen over the last 15 years, I mean, the Title IX process when it comes to sexual assault on college campuses is often referred to in the legal world as, a kangaroo court, because we are expecting university administrators and individuals who are not in the legal world or don't have the experience in doing this to be putting forward and presenting and providing a process and procedure by which by which students can access their rights under that process. And so the same thing applies here. Are we expecting that individuals who are engaged in these processes and in negotiating these contracts, in developing what and deciding what are going to be the things that should be included in these contracts, are we expecting it from individuals who don't necessarily have the education or training in that, and how do we do that? It's an investment by the institutions in making sure that what is being presented to the student athletes comes from a place that has experience.
Couple of things, Matt. I think we have to understand two things. Number one, college sports, the economics of college sports right now are governed by a settlement of an antitrust lawsuit. It's not governed by people who created football issues or basketball issues or baseball issues. It's created by lawyers, Jeffrey Kessler and the NCAA lawyers. This is what we're operating under. Number two, I think there's a real misconception about revenues and expenses and bottomless pits in college sports. Like, as an athletic director told me, you can't revenue share when there's no revenue to share. Like, we think there's still people out there. I come upon people who think the House settlement rained down $20 million on each school. I'm like, no, that's an expense that wasn't there before. That's new money you have to pay, not money you're getting. And people still don't understand that. Like, I don't see this as sustainable. And we're talking about Title IX and more money for women. Like, where is it coming from? Like, there's just, I know schools are going outside the athletic department to get money. They're begging donors. They're going to the school presidents. They're just stealing Paul to pay Peter or whatever it is. It's like this is out there. Like they're sure everyone thinks about the Ohio State football or Kentucky basketball, but as Christine said, those aren't the 1%. Those are the 0.0001%. And the 300 schools or whatever that have opted into this, I'm just wondering. I mean, we've seen Utah go to private equity. We're going to see more of that. Everyone's going to look for cash infusions because this money is not sustainable as we see here today.
Sure. And this may not be a bad place for us to begin to wrap up. And I have attempted to do this in my reporting, and it's hard to not fall into this trap sometimes. But I would say that, in my view, Andrew is exactly correct in that the House settlement does not necessarily represent pure revenue sharing. It represents an opportunity for institutions to decide whether they want to pay this amount of money. And I am aware of several low major institutions that, if we can look at their MFRS report, and show that they have total operational expenses, sometimes of under $30 million, somewhere not even close to Kentucky basketball or Ohio State football, that are sharing some money. Even if, as we might understand it, they're not getting revenue, they are finding ways to scrounge up money to give to athletes, and that may have political risks or financial risks or operational risks down the line. It is hard. The saying that I use at Extra Points a lot, somewhat tongue in cheek, but not always, is money isn't real. Whenever you see somebody, get a salary increase by 3x or anything else, because if we just look at the data we have now as a P&L, it doesn't add up. Can it continue to not add up for another 60 years? I don't know. I'm but a humble scribe. But yes, a lot of this world doesn't seem to make 1 + 1 = 2 in a lot of ways. And that is the reason why I am very grateful to have had all of your expertise and your patience here as you've been willing to chat with all of us. Attendees, please join me in thanking these 4 individuals for sharing some of their time and their talent and their expertise here with this group. My understanding is that there will be a recording of this conversation that can be distributed later. Thanks to everybody else that submitted questions in the Q&A. I apologize for not being able to share all of those over the course of here. Getting a really good question about sovereign immunity with like 4 minutes as we're about to wrap up. I'm like, I want to ask that, but I was told in no uncertain terms to wrap up before 3:30, and that feels like the kind of thing that generally can't be resolved in 1 or 2 sentences. So thank you all very much here for joining us, and we look forward to hearing from you and seeing you in future Drake Group webinars moving forward.